Obviously, in civil litigation, the goal is always to reach a favorable outcome to you. Unfortunately, that is not always the case, and in the event that you do not prevail, we are available to assist you with the next phase of litigation. If there's some error in the trial level that ultimately affects the outcome of the case, then we are able to assist you with filing an appeal. That error would be the ground for the appeal and might give the appellate court a chance to overturn the decision below. The process begins by providing the records to the appellate court. The case is submitted to one of the 5 district courts of appeal in the state of Florida, and then we will prepare an initial brief in which we walk the new court through all of the proceedings before, the factual background, the legal issues, and point out exactly the error that we believe needs to be corrected. There is then an opportunity for the other party, the appellee, to respond with an answer brief, and then one final chance for us to respond with a reply brief. If one or both parties request oral argument, then the court will set it for hearing, and the entire case will be heard by a 3-judge panel at the court. Oral argument does not require the introduction of new evidence or testimony. It will merely be a review of everything that occurred at the trial court before, and will be a discussion between the 3-judge panel and the attorneys for the parties, discussing what the issues were, the legal analysis that's relevant to the case, and the reasons for reversing. After the oral argument is complete, the court will then reconvene and discuss the issues raised at oral argument and ultimately issue an opinion in which they either affirm the decision of the court below, deciding that there was no error, or reverse and possibly send it back for a new trial, new hearing, or simply the entry of a new judgment.